The Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you. Welcome to 2 o'clock docket of the Court of Criminal Appeals in East Tennessee. On the panel today, to my right will be Judge Robert Holloway from Columbia, Tennessee. To my left, Judge Robert H. Montgomery from Kingsport. And I am Kerwood Witt, and I'm from Monroe County. Call the case, Mr. Clerk.
Howard Burnett versus State of Tennessee.
Arguments 20 minutes aside. Mr. Hedrick, as you well know, if you want to reserve a portion of that, you need to make an announcement at the beginning of the argument. Go ahead.
May it please the court. Good afternoon, Your Honors. My name is Joshua Hedrick, and I'm here on behalf of Mr. Howard Burnett. With the court's permission, I'd like to reserve 2 minutes of my time for rebuttal argument, please.
Yes, sir.
The trial court's denial of Howard Burnett's petition for post-conviction relief in this case should be reversed because the state failed to overcome the presumption of prejudice resulting from the improper communication between the trial jury and the court officer in this case. In short version, during deliberation of this case, a court officer gave the jurors an incorrect answer relating to a question about unanimity and the order of consideration with respect to the offenses at trial. This communication was brought to the attention of the trial court, and trial counsel did not at that time move for a mistrial, and the case proceeded to verdict and direct appeal. The improper communication in this case raises a presumption of prejudice. We know that from our Supreme Court's holding in Walsh v. State, that's 166 Southwest 3rd, 641, specifically 647 is the site that I would rely on for that proposition. And the Walsh case is quoting the Blackwell case, which can be found at 664 Southwest 2nd, 689. Blackwell is another Tennessee Supreme Court case, and in Blackwell, the Supreme Court held that the defendant does not have to show prejudice, doesn't have the obligation, rather, to show prejudice from an improper influence upon the jury. Instead, there is a presumption of prejudice that must be rebutted by the state once the defendant establishes that there was improper influence upon the jury. So in the case at hand, there is no doubt that there was an improper communication. We know that from the record at the original record from trial, which the post-conviction court took judicial notice of. That transcript at page 726 reflects the court's discussion of what had transpired. And then on post-conviction hearing in our transcript, our record at page 18, is a discussion from trial counsel testifying at the post-conviction that there was this improper communication. So there's no doubt that it occurred. And there's no doubt that trial counsel failed to move at the time for a mistrial. Trial counsel specifically testified that he did not, and a review of the transcript from the original trial indicates that no such motion was made. When asked on post-conviction whether there was a reason he did not make such a motion, the answer was that he had no explanation for the failure to move for a mistrial, and that had that happened today, he would have so moved. So we know that trial counsel's failure to move for a mistrial was not a strategic decision on the part of trial counsel. And so I've gotten ahead of myself just a bit. What I'm referring to right there is at page 20 in our record. So because the record establishes that there was an improper communication, and because the record establishes that occurred without any curative efforts on the part of trial counsel, the burden is upon the state to rebut the presumption that there was prejudice. Now, in this case, the state has not
Before you
rebutted.
go any further, Mr. Hedrick, let me ask you this. Does the record reflect where this communication occurred? Was it in the hall? Was it in the jury room? Was it in the courtroom? Do we know where it occurred?
We know that it was not. I don't know that I can necessarily say with certainty from the record where it occurred. It was not in the courtroom. It appears to have been in the jury room. It appears from the record that the lawyers were brought back into the courtroom to be made aware that this communication had occurred during deliberations. And from that, we conclude it must have been in the jury room or around the jury room, because it didn't occur in the courtroom. It occurred during deliberations. And then after counsel was brought back in, then the trial court re-instructed the jury, brought the jury into the courtroom and instructed them again on the order of consideration and the necessity for unanimous verdicts, and then returned them for deliberation. So okay. I can't say that the record is explicit, but we know it's not in the courtroom.
Okay.
So in this case, the state has not rebutted this presumption neither by evidence nor by argument. At the post-conviction hearing, the state presented no proof and presented no argument. The state's argument in its entirety is contained at page 29 of the post-conviction record, wherein the state's 31, at 31 in our record. And at 31 in our record, the state's entire argument, it consists of, and I quote, "No," meaning the judge asked, "Do you have anything you want to say?" And the prosecutor says, "No, I mean harmless error with respect to the court officer. We were fortunate it was brought to the court's attention when it was, because she had an opportunity. It happened very quickly, and she addressed it quickly in court." And then the trial court interrupts counsel for the state, and there's a discussion about whether there was a curative instruction given. And so what we have here is a case where the state has not rebutted the presumption of prejudice, and where the state has not, at the post-conviction stage, asserted waiver. Now, this court has had the benefit of the briefing of the parties, and the state, in its brief, asserts that this issue was waived because it was not raised on direct appeal. Respectfully, that argument is not consistent with what happened in this case. If we look to the case of Walsh versus State, we see that this case is identical to that of Walsh. And Walsh, if you recall, was at 166 Southwest 3rd, 641. And Walsh dealt with almost the identical issue. In Walsh, an improper comment was made to the jury by a court officer, and it was held that that comment raised the presumption of prejudice. At the post-conviction stage, Walsh, the presumption was not rebutted by the state, and neither did the state in Walsh assert that it had been waived by failure to raise it on direct appeal. And so in Walsh, the court ruled that the state's waiver argument on appeal was waived by the state's failure to raise it at post-conviction. That seems confusing, and it took me a while to work my way through that. But what Walsh stands for is the state cannot argue waiver on appeal if it did not raise it at the post-conviction hearing. So just as in Walsh, whether Mr. Burnett raised this issue on direct appeal or not is not controlling, partly because the state waived that issue by not raising it in the post-conviction, and partly because that is the ineffective assistance in the event that it's waived, then it becomes ineffective assistance, because trial counsel did not move for a mistrial and did not press that issue on direct appeal. So we would urge this court to find that there is a presumption of prejudice based on the improper communication, that the presumption has not been rebutted, and therefore there was prejudice in this case, and post-conviction relief is appropriate. This court's urged to find that the state has waived its waiver argument by not asserting it at the post-conviction trial. And alternatively, to find that any failure to raise this issue either by motion for mistrial at the trial court or on direct appeal is ineffective assistance of counsel, which pretermitted Mr. Burnett's ability to raise this issue and therefore was prejudicial to him. I'm sorry, Your Honor, you may be on mute.
There you go. Sorry. There may be a step missing in what happened in this case, and that's the state putting on some proof. But once the trial court gives a curative instruction and basically instructs the jury to disregard what the bailiff told them, here's the law. How does that not overcome any injury to the defendant and do away with prejudice?
If Your Honor, please, that is a difficult question for me to answer, because the jurors are presumed to follow the court's instruction. However, because of our rules of evidence, this court's well aware that we cannot bring the jurors in to inquire from them what their decision was based on. And so we have no way to know if the trial court's curative instruction was understood or followed, or if it just further muddied the waters. Because we have to remember that this was a jury that was instructed on this point initially. And then there was some confusing communication from the bailiff, who the jurors looked to as an authority figure, right? And then some additional instruction from the court. The reason why we have, if I may be so bold, the reason why we have this presumption of prejudice is because we're not able to bring a juror in, put them on the stand, and ask them, why did you make your decision? What did you consider? And so I think that although that's a difficulty for us, I don't know that it's fatal. And so for those reasons, if Your Honor, please, we would ask that the denial of the petition for post-conviction relief be reversed. Thank you.
Thank you. General Lohr.
Good afternoon, Your Honors. May it please the court, Courtney Lohr on behalf of the state. I want to take a moment to just clarify that this issue is before this court as an ineffective assistance of counsel claim. This issue is not before this court as a standalone due process claim about improper communication with the jury. And because this issue is raised as ineffective assistance of counsel, the presumption of prejudice does not exist, and Walsh does not control the analysis of this case. As counsel correctly noted, in Walsh, the petitioner raised a standalone claim regarding improper communication between the bailiff and the jury. The state did not argue waiver as to the standalone claim at the post-conviction hearing, and instead argued waiver for the first time on appeal. The Tennessee Supreme Court held that the state's waiver argument was waived because it failed to raise it below and addressed the defendant's claim as a standalone due process violation on post-conviction. Here, this issue was raised as an ineffective assistance of counsel claim, and the state properly did not argue waiver below because ineffective assistance of counsel was not waived by failing to raise the issue on direct appeal. Now, the defendant attempts to blur the line between the ineffective assistance of counsel claim and a standalone due process claim to reach this presumption of prejudice. And here, to the extent that this is raised on appeal for the first time as a standalone due process claim, it is waived for failure to raise it as or on direct appeal. However, as presented at the post-conviction hearing and as presented in the defendant's brief here, this is a ineffective assistance of counsel claim. And this court and Strickland, relying on Strickland, has stated innumerable times before that the petitioner bears the burden of showing prejudice in an ineffective assistance of counsel claim. Walsh and the presumption of prejudice only apply when this is raised as a standalone due process claim, either when waiver has not been properly asserted on post-conviction or under plenary review on direct appeal. Here, the petitioner simply has failed to show prejudice, as Judge Holloway, you noted earlier. The bailiff's sole communication with the jury was an incorrect explanation of how they should include how they should consider lesser included offenses as they deliberated the verdict. The court was immediately informed of this communication, either through the parties or by the bailiff himself. It's not entirely clear from the record who communicated this to the court. The court immediately brought the jury back into the courtroom, informed them that the bailiff's instruction or the bailiff's comment was incorrect, and then gave the correct instruction for the proper order in which to consider lesser included offenses. Any error from the bailiff's communication was immediately rectified by the court. The jury was presumed to follow the corrected instruction, and the petitioner cannot show prejudice in this case. Additionally, the petitioner has failed to show deficient performance, because even though there is some testimony about trial counsel saying he didn't know why he didn't file a motion for mistrial, he may have done that now. That does not overcome the fact that trial counsel was not required to file what he knew would have been a frivolous motion. Here, upon learning of the improper communication between the bailiff and the jury, the court immediately brought the jury back in and gave them the corrected instruction. Trial counsel was not required to make a form motion for mistrial when the court had already exercised its discretion to give what it viewed the proper remedy in this case. So simply put, the petitioner has failed to show that trial counsel was ineffective, and we ask that you affirm the judgment of the post-conviction court.
Rebuttal, Mr. Hedrick.
If the court please, I will gladly answer any questions your honors have, but I don't believe that I have a rebuttal argument to offer at this time. Thank you, your honors.
All right, thank you. Concludes this argument, and the court will be in recess until 9 o'clock in the morning.
This honorable court is now in recess until 9 a.m. tomorrow morning.